The Lagos State Governorship Election Tribunal on Monday affirmed the re-election of Governor Babajide Sanwo-Olu, dismissing the petition of the governorship candidate of the People's Democratic Party, Olajide Adediran, and the other one filed by the Labour Party candidate, Gbadebo Rhodes-Vival. Justice Michael Abdullahi held that Sanwo-Olu and his deputy, Dr. Hamzat, were qualified to contest the March 18, 2023 governorship election in the state under Section 177 of the Constitution. The judge held that they are members of political parties and educated up to school certificate level. But we are now being joined by the chieftain of the ruling All Progressives Congress, Wahab Shittu, to discuss that tribunal judgment and how to heal the wounds and divisions caused by the election. Good afternoon and good to have you again on Arise News.
Good afternoon. It's my pleasure to be here. Now, just to correct the impression, I'm not a chieftain of APC. I'm a senior advocate of Nigeria, a legal practitioner.
Well, thank you very much for that clarification. Well, as a senior advocate of Nigeria and as a legal practitioner, can you give us your reaction to this ruling?
I think the reaction is expected, is salutary, is in conformity with the provisions of the Electoral Act, is in line with popular will. It also reflects the wishes of the people of Lagos State who have overwhelmingly voted for Babajide Sanwo-Olu and Hamzat as governor and deputy governor of Lagos State. So I think the ruling, it shows that if you look at the prayers of the PDP candidate, Jandor, he is saying that the governor and the deputy governor be disqualified on the ground that they were not validly nominated and that they were not qualified to contest the elections. If you look at sections 177 of the Constitution, there are about 5 fundamentals that defines whether you are qualified to contest for the governorship of any state. One, you must show that you are a citizen of Nigeria by birth. You must also show that you have attained the age of 35 years. You must also show that you are a member of a political party and that you are sponsored by that political party and that you are educated up to at least school certificate level or its equivalent. You will note that if you look at all these fundamentals for qualification as spelled out under Section 177 of the Constitution, Governor Sanwo-Olu satisfies all those 5 criteria. He's a citizen of Nigeria by birth. Nobody can dispute that. He's a member of the APC and is sponsored by the APC as a political party for that election. Of course, he's more than 35 years of age and is educated up to at least school certificate level or its equivalent, even more than that. And if you've been following the activities of Governor Sanwo-Olu during his first tenure, you see that he's a governor who has impacted governance in Lagos State. He has raised the bar of governance very high. And the general expectation is that he was popularly elected. They raised the issue that Governor Sanwo-Olu perhaps didn't attend community grammar school in Ijebu-Ife, and that maybe he forged the certificate. But they could not lead any evidence to prove that. For instance, the principal of the community grammar school, Ijebu-Ife, who is alive, was not called to give evidence, and nobody from the grammar school was called to give evidence. So, based on the evidence available to the tribunal, the allegation that the governor forged his certificate was not established. And this is consistent with the provisions of the Electoral Act. If you look at Section 134 of the Electoral Act, the grounds under which you can question an election are clearly specified. Is it that you are saying that somebody at the time of the election was not qualified to contest the election? Or you are saying that the person did not score the majority of lawful votes? Or you are saying that the election was marred by corrupt practices, or that the election was not conducted in conformity or substantial compliance with the Electoral Act. All of these conditions are the conditions under which you can challenge an election. The tribunal rightly found that the governor and his deputy scored majority of the lawful votes, and that none of the conditions are spelled out under Section 177 of the Constitution for qualification was breached. So I think the judgment is very popular. The judgment was based on the facts adduced before the tribunal, which rightly found that the governor was validly nominated by his political party, and the governor was also scored majority of lawful votes, and that none of the grounds specified under 177 was breached to entitle the governor or his deputy from being returned as the duly elected governor of Lagos State. Again, the other issue which came out very clearly is that when you are talking of whether somebody is validly nominated by a political party, it is within the province of the political party to determine its candidate. No outsider can query the way and manner a political party conducts its affairs. So it is not for the PDP candidate or the Labour Party candidate to begin to assert that the governor was not validly nominated.
Right.
Of course, well, apart from the fact that, let me just conclude this.
Okay.
Apart from the fact that it was not proved, it is also something within the jurisdiction of it's an internal party arrangement of APC. And it's supposed to be a pre-election matter, which is outside the jurisdiction of the tribunal. So on all parameters, the judgment as handed down by the tribunal cannot be impeached in any way. It is so sound. It's in line with the established principles of law. And the tribunal members rightly found that the petition lacked merit and ought to be dismissed, and went ahead to dismiss it.
All right. Wahab Shittu, it was very good to have you on the show today. Unfortunately, we have run out of time. We did want to ask you what steps could be taken in order to reconcile the situation we have currently in Lagos State. But we will, once you come on the program another time. Thank you so much for joining us.